Welcome to This Explainer. Look, if you're a father watching this and you've suddenly found that your child has been relocated without your consent, take a deep breath. I know exactly how terrifying and overwhelmingly stressful that moment is. But right now, we need to replace that panic with a solid plan. Think of me as your legal coach today. We're going to demystify child custody disputes by completely replacing emotional reactions with highly strategic, lawful actions. Our entire focus here is on securing your child's future by understanding exactly how Indian courts look at these incredibly sensitive situations.
Okay, let's dive into this. Here's our roadmap for today. We'll cover when a child is relocated, father as natural guardian, custody versus habeas corpus, building your evidence profile, courtroom composure and temperament, and finally, winning the court's trust. We're basically going to break down this highly charged situation into manageable, structured steps focused entirely on your child's welfare.
Section 1. When a child is relocated. Let's start right in the middle of the immediate crisis, when a child is secretly relocated. Waking up to find your child has been taken from the matrimonial home or just moved to another city without a word is a massive emotional shock. But listen, it's right here, in this exact moment of crisis, where the biggest legal mistakes happen.
So, what is your absolute first move when your child is taken without consent? Your gut instinct might be to retaliate, right? To forcefully go get the child back, or to just bombard your spouse with angry texts. And hey, I validate your panic. It's a totally natural human reaction. But as your coach today, I'm telling you, you need to pivot immediately to calculated lawful restraint.
Here are the precise steps you must follow instead. First up, maintain total composure. Aggressive actions or any kind of illegal retaliation will inadvertently destroy your future legal custody claims. You literally cannot afford it. Second, send a calm, written communication, like an email or a text, asking about the child's safety, their location, and schooling. What you're doing is creating a paper trail of a concerned, rational parent. Third, file for interim visitation and custody without delay. Remember, courts don't reward revenge, they reward responsibility.
Section 2. Father as natural guardian. That brings us to our next crucial phase, grounding you in your actual legal standing. We need to shift your mindset right now from feeling like a defeated spouse to acting as an empowered natural guardian.
So, under Section 6 of the Hindu Minority and Guardianship Act of 1956, the father is legally recognized as the natural guardian of a legitimate minor child. But there's a catch you really must understand. Courts do not award custody based solely on gender or titles. They prioritize what's called the welfare principle. This basically means the judge is looking at who can provide the absolute best overall growth, health, and developmental opportunities for the child.
And this brilliantly illustrates how the Supreme Court balances this out. In landmark rulings like Tijjaswini God, they establish that the paramount consideration for the court ought to be child interest and welfare. This precedent completely dismantles the myth that maternal relatives automatically win custody just because they currently have the child. Your legal right as a natural guardian is powerful, provided you can actually prove you serve the child's best interests.
Let's look at another really critical precedent. In the Gautam Kumar Das case, we see that temporary custody held by a relative does not permanently block a father's claim. So even if your child has been left with an aunt or a grandparent, a capable, stable, and involved father remains the rightful guardian in the eyes of the law. You are not permanently locked out just because the child is currently somewhere else.
Section 3. Custody versus habeas corpus. So, how do we legally bring the child back? Let's move into the tactical execution phase. I want to explain the exact legal pathways available to you, just like a seasoned attorney would sit down and map them out for you.
You generally have two main routes here. A habeas corpus petition is filed in the High Court for urgent intervention, like when a child is illegally detained, spirited away, or when immediate police intervention is needed to enforce an existing court order. On the flip side, a standard custody application under the Guardians and Wards Act is for establishing long-term welfare, shared parenting, and permanent guardianship. Your lawyer will help you choose, but generally speaking, if the mother has simply moved to her parents' house with the child, you'll usually need the standard custody route.
But whatever you do not wait. Delay literally kills custody cases. Under the Guardians and Wards Act, jurisdiction lies where the child ordinarily resides. If you wait a year to file, the court might rule that the child is now settled in the new city. They're enrolled in a new school, and it's no longer in their best welfare to uproot them all over again. You absolutely must act urgently.
To stop the clock, there are some rapid legal shields you should consider filing right alongside your main petition. You want an interim visitation application so you don't lose contact. You need injunctions to legally prevent the spouse from changing the child's school or relocating them even further away. And if there is any flight risk whatsoever, you absolutely need passport or travel restraint orders so your child isn't taken abroad without your consent.
Section 4. Building your evidence profile. Filing the case is just step 1. Now we transition to the burden of proof. It's time to build your evidence profile. How exactly do you document your capacity to care for your child in a way a judge will actually respect?
I want you to use the rule of 3: school, health, and wealth. Please don't just walk into court and say, "I'm a good dad." You have to prove it. Bring folders of school diaries and PTA records. Compile medical logs, vaccination records, health bills. Bring photos of daily joint activities. And I don't just mean vacations, I mean everyday moments like helping with homework. Provide financial records proving your long-term support, and keep meticulous logs of all your consistent visitation attempts. Objective evidence proves an active, child-centric role infinitely better than mere verbal claims.
And listen to me very carefully on this next point. Do not stop paying for child expenses. It is a disastrous behavioral mistake to withhold money just to teach your wife a lesson during a dispute. The court doesn't see it as punishing the spouse. The court sees it as you abandoning your child's needs. Maintaining that financial support is critical during disputes to prove your long-term capacity and responsibility.
Now, as the dispute drags on, you might encounter something called parental alienation syndrome, or PAS. This is a highly damaging strategy where a child is psychologically manipulated into showing unwarranted hostility or fear towards you. While the Supreme Court absolutely recognizes the psychological harm of PAS, you cannot just throw this accusation around prematurely in court. Judges require hard, documented evidence of alienating behavior.
So how do you legally prove alienation? Methodically. Keep detailed call logs showing exactly when your attempts to contact the child were blocked or ignored. Save texts or emails where threats of cutting you out were made. Document every single time a court-ordered visitation was denied. You are essentially building a bulletproof paper trail of the other parent's hostility without ever engaging in it yourself. Section 5. Courtroom composure and temperament. This naturally leads us right to the psychological battleground. Judicial investigators and judges are scrutinizing your behavior just as closely as they are scrutinizing your evidence.
Now, what's really interesting about this is how easily minor behavioral traps can destroy a case. Damaging behaviors like emotional outbursts, aggressive texts, withholding financial support, or fighting just to defeat the spouse, those will sink you. Instead, focus on winning behaviors. Maintain calm, respectful, and polite communication. Pay child-related bills consistently, and frame every single argument around what is best for the child. Composure wins judicial trust, hands down.
Keep in mind, court investigators are highly trained. They observe your temperament to distinguish genuine, deep-rooted parental concern from purely tactical legal maneuvers, like, say, a father who is just using the child as a pawn to get a better divorce settlement. By remaining an emotionally stable figure during heated interactions, you completely prevent the court from labeling you as volatile or unsafe.
Section 6. Winning the court's trust. We are bringing this coaching session to its climax now. Everything we've discussed today culminates in one ultimate goal: winning the court's trust. You do this by aligning your goals entirely with the court's overarching philosophy.
So the crucial point to remember is this. The courtroom question is absolutely never who has more rights, the mother or the father. No. The only question the judge is asking is, where is the child's welfare better protected? You must reframe your entire legal battle from a fight for father's rights to securing the child's right to their father.
I want you to let this powerful precedent from the Supreme Court of India really sink in. A child is not an inanimate object to be tossed from one parent to another. The child needs love, affection, company, and protection of both parents. The highest court in the land recognizes your indispensable role in your child's life. The law isn't against you, but you absolutely must play by the rules of welfare and stability.
I'm going to leave you with this final provocative thought. Are you fighting to defeat your partner, or are you fighting to protect your child's future? Because if your answer is the latter, you are ready. Keep your composure, gather your evidence objectively, and go consult with a specialized matrimonial lawyer who has a strategic, child-first mindset. Thank you so much for joining me in this explainer, and I truly wish you the best of luck in securing your child's future.